Good afternoon, everyone. Thank you for joining the webinar. Today, I will share with you the first part of the webinar about the overview of licensing conditions of moneylender's license. Before I start, I would like to remind you of the restrictions on carrying on moneylender's business. According to Section 7 of the Moneylender's Ordinance, no person shall carry on business as a moneylender without a license. And licensed moneylender shall not carry on moneylender's business in the premises other than that specified in its license, and shall not carry on moneylender's business otherwise than in accordance with the licensing conditions. If licensed moneylender is in serious breach of the licensing condition, the licensing court may revoke or suspend its license. According to Licensing Condition 1, before entering into any agreement for loan, the moneylender shall ask the intending borrower to state in writing whether or not he has entered into or signed any agreement with any third party for or in relation to procuring, negotiation, obtaining, or application of the loan, guaranteeing or securing the repayment of the loan. And this agreement is the so-called third-party agreement. And please note that an agreement with a solicitor instructed by the intending borrower for provision of legal services solely, for example, to review the loan documents, is not a third-party agreement. If the intending borrower has entered into or signed any agreement with the third party, the moneylender shall state in writing in the loan agreement the name and address of the third party, and whether the moneylender is in any way related to the third party and the nature of such relationship. This document should be prepared by the moneylender, and the moneylender should ask the intending borrower to personally provide a copy of the third-party agreement and attach the third-party agreement to the loan agreement. And as you can see on the screen, this is the Annex 1 of the Guidelines on Licensing Condition of Moneylender's License, which is a sample form on disclosure of the existence of third party by intending borrower. And this is the Annex 2 of the Guidelines on Licensing Conditions, which is a sample form on recording the particulars of appointed third party involved in a loan agreement. And under Licensing Condition 2, unless the third party has been appointed by the moneylender as appointed third party and has confirmed in writing to the moneylender that he has not charged and will not charge any fees, however named, from the intending borrower, and has not otherwise agreed with the intending borrower that the intending borrower pays or would pay any fees, however named, to any other party, whether for the purchase of any goods or services or not. Otherwise, the moneylender shall not grant or agree to grant any loan to the intending borrower. And this is the Annex 3 of the Guidelines on Licensing Condition. It is a sample form on confirmation by the appointed third party on the charging of fees. And according to Licensing Condition number 3, the moneylender shall provide in writing to the satisfaction of the Commissioner of Police and the Registrar of Moneylenders the name, address, and identification number of the appointed third party. The third party is not considered as an appointed third party until after the name and address of the appointed third party appear on the register kept by the Registrar of Moneylenders. And the forms for reporting information of appointed third parties can be downloaded from our website. As you can see on the screen, there are forms MLATP1, MLATP2, and MLATP3, which are used to report the appointment of third party, the change in particulars of appointed third party, and the termination of appointment of appointed third party, respectively. And the list of appointed third party can be obtained from the company's registry website. The particulars of appointed third parties can also be searched from the e-services portal of the company's registry. According to Licensing Condition 4, the moneylender shall not knowingly allow or permit any person to charge, recover, demand, or receive any fees, however named, from any borrower or intending borrower. Please note that the terms any person includes the moneylender or his partner, employers, employees, principal or agents, or any person acting for him, or any appointed third party. And please note that borrowers shall not be required to purchase goods or services, and shall not be charged with processing fee or administrative fee. And no fee charging provision can be contained in the third-party agreement. According to Licensing Condition 5, before entering into any agreement for loan, the moneylender must give explanation to the intending borrower of all the terms of the agreement, in particular the interest rate expressed as a rate % per annum, and the total amount of interest payable, and the amount of repayments, periodically and in total under the agreement, the possible consequences of any defaults in repayment, including the taking into possession and sale of any security involved, and any overriding rights of the moneylender to demand an immediate repayment. The moneylender must keep written or video or audio records to show that he has complied with the requirements under this condition. And this is the Annex 6 of the Guidelines on Licensing Conditions. It is a sample form for recording explanation of terms of loan agreement given to the intending borrower. And there are a few points for you to pay attention to. The first one is that moneylenders should clearly explain to the intending borrower all the terms and conditions of the loan agreement, but not merely the crucial parts of the loan agreement. Secondly, even if the intending borrower states that there is no need for an explanation, the moneylender should still comply with this requirement to provide an explanation before entering into any loan agreement. And the Licensing Condition 5 covers all kinds of moneylender, including moneylenders who establish business relationship with borrower by a long face-to-face approach and keep records in video or audio form. Under Licensing Condition 6, there are two situations that the moneylender shall not obtain or collect personal data of any persons from another person or use such personal data obtained or collected from another person for the purpose of or in relation to the moneylender's business. The first situation is that without the written confirmation from that other person that the disclosure or provision of such personal data by that other person for such use of the moneylender is not in contravention of the provision of the Personal Data Privacy Ordinance. And the second situation is that when the moneylender has knowledge or has reasonable grounds to believe that the disclosure or provision of the personal data by that other person for such use of the moneylender is likely to be in contravention of the provisions of the Personal Data Privacy Ordinance. A moneylender must keep records to show that he has complied with this requirement and the provisions of the Personal Data Privacy Ordinance. Under Licensing Condition 7, the moneylender shall not accept a subsidized flat provided by the Hong Kong Housing Authority as collateral for the loan to the borrower, unless the borrower has produced to the moneylender either a written confirmation from the Hong Kong Housing Authority that the necessary premium for removing the restrictions on alienation of the said flat has been fully paid, or the written approval of the Director of Housing granting approval to mortgage or charge the said flat. And under Licensing Condition 8, the Chinese version of any advertisement issued or published by the moneylenders for the purpose of the moneylender's business as a moneylender must clearly show the following Chinese character, and immediately followed by the number of the moneylender's license. And here is the example. According to Licensing Condition 9, any advertisement in relation to the moneylending business, whether in whether in textual or audio or visual form, must be fair and reasonable and not contain misleading information, and must contain moneylender's telephone hotline for handling complaints and a risk warning statement. And this is the risk warning statement. The risk warning statement must be in the same language as that of the advertisement or relevant parts thereof, and clearly audible in the audio part of the advertisement. And to ensure that the advertisement is fair and reasonable and does not contain misleading information, the advertisement must not contain information that is misleading or deceiving, and must not emphasize any potential benefits of a product or service without also giving a fair and prominent indication of any relevant risk, must not disguise, omit, diminish, or obscure any relevant fact which will result in the information or message being insufficient, unclear, unfair, or misleading. Any information must be in a conspicuous text and placed in a conspicuous position in the advertisement. And the advertisement should not carry information that understates the cost of borrowings and overstates the ease of borrowing. And the company's registry has issued guidance for the display or broadcast of risk warning statement for different types of advertisement. For advertisement in print, the risk warning statement should be displayed in text in at least 50% of the font size and in the same font type and color as the other content of the advertisement that bears the largest font size. For audio-visual advertisement, the risk warning statement should be in clear contrast in color with the background or backdrop of the advertisement. Where the risk warning statement appears in an independent screenshot, it should be displayed visually at the end of the advertisement for at least 3 seconds, with a clear readout for the same duration. When it appears throughout the entire advertisement, it should be shown clearly at the bottom of the screen, with the height of each Chinese character be at least 1/15 of the screen, and with the height of capital letters of the English statements be at least 1/20 of the screen. And it also needs to come with a clear readout in the same pace as other contents of the advertisement. For internet advertisement, there are 3 types of them. The first one is website banner. When you click the banner, you will be linked to another website. In this situation, the risk warning statement should be displayed on the landing page of the website in text in at least 50% of the font size and in the same font type and color as the other content that bears the largest font size on the landing page. For advertisement with a static screen on the internet, the guidance for advertisement in print applies. Similarly, for audio-visual advertisement on the internet, the guidance for display of risk warning statement in audio-visual advertisement applies. And for licensing condition 8 and 9, there are a few points for you to pay attention to. The first one is advertisement relating to money lending business, including all kinds of publicity materials, shall comply with the licensing condition 8 and 9. And moneylenders shall ensure the display of valid moneylender's license number in advertisement. And the advertisement must contain a complaint hotline. Please note that application hotline or inquiry hotline is not equivalent to complaint hotline. And the name of moneylender as specified in the license, not only a business name, must be shown in the money lending advertisement. This requirement is come from the Section 26 of the Moneylenders Ordinance. And if an advertisement states that certain loans are interest-free or zero interest, etc., it will give the impression that there are no interest or monthly fees. If a monthly administrative or handling fee is charged, the advertisement will be misleading. And moneylenders post on social media, including but not limited to its pictures, videos, and captions may be regarded as one or more advertisements, depending on the actual situation. Moneylenders should ensure that such posts comply with the licensing conditions 8 and 9. Under licensing condition 10, the moneylender and its debt collector shall not try to recover debts, whether directly or indirectly, from anyone, for example, the referees or the borrower's family members or friends, unless such person is in law indebted to him, and shall not harass anyone, and shall not adopt unlawful or improper debt collection practices. The moneylender shall ensure the personal data connected are protected against unauthorized or accidental access, processing, erasure, or other use by the debt collectors, and shall comply with the Personal Data Privacy Ordinance, and shall maintain and monitor proper system and procedure for handling complaints and inquiries relating to the loan lent by him in the ordinary course of business, and the debt collection activities arising therefrom, and shall keep updated and accurate records of the debt collection activity of its debt collectors during the terms of the license. Please note that the records should at least include the dates and methods of the debt collection activities. Please also note that whether the debt collector complies with the law and the relevant requirements under condition 10 in his debt collection activity is a factor for determination of whether the moneylender is a fit and proper person to carry on business as a moneylender. And moneylenders must exercise proper care and diligence to monitor the debt collection activity of their debt collectors. And the debt collectors should not be given a free hand as to the debt recovery procedures. According to licensing condition 11, the moneylender shall provide information relating to his moneylending business during the term of the license as may be required by the Registrar of Moneylenders or the Commissioner of the Police, within such time as specified. For example, the annual exercise for collection of financial information, thematic surveys, and quarterly return on personal loan, where the Registrar of Moneylenders requires the moneylender to participate. And under licensing condition 12, the moneylender must establish and maintain proper systems and procedure to ensure that the following parties shall be informed of and observe the licensing conditions and the provisions of the moneylender's license. The parties include moneylenders or his partners, employers, employees, principal agents, person acting for him, and appointed third party. And the system and procedure includes management and supervision, personnel and training, review of appointed third party, and record keeping. And under licensing condition 13, where any referee is provided in respect of the loan application, the moneylender shall, before entering into any agreement for loan, ask the intending borrower to provide the written consent signed by the referee, confirming his agreement to act as referee in respect of the loan application, and the moneylender shall attach the written consent to the loan agreement. And if the moneylender is informed of or aware that the written consent was not signed by the referee, the moneylender shall immediately cease to use the information of the referee. And referee is a person who, on a voluntary basis and upon request by the moneylender, to provide information about the intending borrower in respect of the loan application. For example, for identification purpose of the intending borrower before entering into the loan agreement. And please note that referee is not for debt collection or for contacting the borrower after the loan agreement has been entered into. And this is Annex 5 of the Guidelines on Licensing Conditions, which is a sample form on written consent by the referee for loan application. And under licensing condition 14, the moneylender must comply with the guidelines on compliance of anti-money laundering and counter-terrorist financing requirements for licensed moneylenders and must assess the money laundering and terrorist financing risks of their businesses, develop and implement policy, procedure, and control on the following areas, including risk assessment, customer due diligence measures, ongoing monitoring of customers, suspicious transaction reporting, record keeping, staff training, and independent audit function. The guideline can be downloaded from the company's registry website. And under licensing condition 15, before entering into agreement for or before granting any significant increase in the amount of loan under an agreement for unsecured personal loan, the moneylender shall undertake an assessment of intending borrowers or borrowers' ability to make repayments under the loan agreement affordably and have due regard to the outcome of the assessment in respect of affordability. In carrying out the assessment, the moneylender shall consider the intending borrowers or borrowers' current income and expenditure and their abilities to make repayments under the loan agreement as they fall due over the life of the loan agreement, without having to borrow to meet repayments, without the repayments having a significant adverse impact on the overall financial situation. And the assessment must be reasonable. In doing so, the moneylender must base the affordability assessment on sufficient information available to him at the time of conducting the assessment, the extent and scope of the assessment, the step that the moneylender must take, and the evidence to be taken into account are dependent upon and proportionate to the individual circumstances of each case. The moneylender should adopt a common sense approach and decide what is appropriate and proportionate in the circumstances of a particular case. And in carrying out the assessment, the moneylenders shall consider the following factors, including the total amount of principal and interest payable, the duration of the term for repayment of the loan, frequency and amount of the repayment, interest rate, the purpose for obtaining the loan, the employment or business of the intending borrower or borrower, current credit and financial information on the intending borrower or borrower, any other potential adverse consequences for the intending borrower or borrower arising under the loan agreement from a failure to make repayment by the due date. And when assessing the current income and expenditure, the moneylender must take reasonable steps to determine the amount or make a reasonable estimate of the current income and expenditure of the intending borrower. When considering the current income of the borrower, moneylenders can consider the salaries as well as other income, such as a dividend or rental income. Also, the moneylenders can consider the savings and assets of the borrower as appropriate. And when considering the current expenditure of the borrower, apart from the existing debt, please be reminded to consider the essential living expenses and other expenditure, which is hard to reduce to give a basic quality of life of the borrower. And the moneylenders can also consider whether there is any foreseeable change in the income and expenditure of the borrower. And the moneylender must also keep written or video or audio records to show that the requirements under this condition have been complied with. And the moneylender should establish, implement, and maintain clear and effective written policy and procedures, and set out the principal factors it will take into account in carrying out the assessment. And for licensing condition 15, there are also a few points for you to pay attention to. The first one is the self-declaration of income and expenditure by the borrower or intending borrower is not an affordability assessment. The moneylender must base the assessment on sufficient information available, with evidence to show the assessment is carried out by the moneylender. For example, by signing and dating the written assessment. And the assessment record must show the factors that the moneylender has considered, especially the special factors. The moneylender must ensure the information shown in the assessment matches the information provided by the intending borrower or borrower. For example, the information from the loan application form or proof of income. And the moneylender should adopt a common sense approach and decide the reasonableness of information provided by the intending borrower or borrower. The moneylender should require the intending borrower or borrower to provide relevant supporting document if appropriate, and keep copies of the supporting documents. And please note that in addition to new loan agreements, the above-mentioned licensing conditions relating to loan agreement also apply to the extension or renewal of loan agreements. When entering into any extension or renewal of loan agreements, moneylenders are also required to comply with the relevant licensing conditions. And the company's registry has issued various guidelines. And the first one is the guidelines on licensing conditions of moneylenders license. And the second one is the guideline on compliance of anti-money laundering and counter-terrorist financing requirement for licensed moneylender. And the remaining two guidelines are guideline on fit and proper criteria for licensing of moneylenders and the guideline on submission of business plan by applicant of a moneylender's license. And these four guidelines can be downloaded from the company's registry website. And this is the inquiry hotline and the email address of the moneylender session. If you have any question, you may make a call to us or send an email to us. This is the end of my sharing. Thank you.